What role would you say a management company play in the day-to-day running of a leasehold block?
So where you've got a bigger property, I think the managing agent's really important. They need to make sure that it's kept up to a reasonable standard, that there's no water leaks, that the investment both for the leaseholders and the freeholder is looked after so that they can all sell the property, enjoy the property as well. It is difficult with some managing agents, I know, to get hold of them, and it would be good to have them more regulated so that they provide a more consistent approach and dealings with things for the leaseholders and the landlords.
Welcome to Listen Without Prejudice, the podcast from Bishop and Sewell. Each episode brings you expert insights, practical advice, and real stories from one of London's leading law firms. From property and private client matters to business law, family, and dispute resolution, we're here to inform, guide, and inspire. Let's get started.
Hello, welcome to our podcast today. I'm Karen Bright, and I'm head of our litigation department and deal with property disputes and insolvency. I've got with me today Farzana Rahman, who's an associate solicitor in our residential property team. Hi, Farzana.
Hi, Karen. I thought we can touch on management agents, management companies, and the management pack that they provide. The management pack, also known as the LPE1 pack, is a really important set of documents. I think all solicitors on a leasehold purchase would want to obtain this pack. It contains very important information about service charges, ground rent, insurance, major works. It's a form with a lot of questions, and it's something I think as solicitors we need in order to be able to advise our clients fully and correctly. Karen, do you find the costs of management packs reasonable?
I don't tend to hear clients complain too much about the cost of the LPE ones. What I tend to find is that they complain when they can't get one because the buyers then aren't keen to buy somewhere where they don't know what the service charge liability is, whether there have been any breaches of lease, which are questions I believe that are often in these documents, and where we can't get a landlord or managing agent to provide the document, often the sale falls through, which puts the seller in a really difficult position. So whilst £400 or say £500 for a very short form seems expensive, it's probably not the bigger issue here. That the bigger issue is if you can't get that document and you can't sell your property, what do you do? And there is no easy answer to it. There is no contractual obligation for a landlord or managing agent to provide those documents.
Yeah.
We often find where we've got share of freehold that this is a particular issue because the freeholders, also leaseholders, don't realise they need to provide it. They've also not been managing the property in the routine way that managing agents would, and therefore they either don't complete it, can't complete it, or they complete it themselves, which the buyer then won't accept because it's come from the seller.
What role would you say a management company play in the sort of day-to-day running of a leasehold block?
So where you've got a bigger property, I think the managing agent's really important. They need to make sure that it's kept up to a reasonable standard, that there's no water leaks, that the investment both for the leaseholders and the freeholder is looked after so that they can all sell the property, enjoy the property as well. It is difficult with some managing agents, I know, to get hold of them, and it would be good to have them more regulated.
Yeah.
So that they provide a more consistent approach and dealings with things for the leaseholders and the landlords.
Yeah, I agree. What happens if we can't get answers from the landlord on an LP1?
It's really difficult. There's no easy answer to that. The only way to attack that problem is by going to the tribunal and asking them to appoint a manager to manage the building. And then once you've got a manager appointed, you can then ask that manager to provide those details, which when we talk here sounds like a very quick process. It's not. You have to serve a notice first detailing all the issues with the property. And you have to show fault. So you have to show that the landlord's not been maintaining the property, not providing the LPE1. That all has to be set out, notice served. They have to have a reasonable time to try and rectify the issues. And if not, then you apply to the tribunal to appoint a manager. That process alone can take up to a year and is very costly. And even once you've got a manager appointed, that manager is answerable to the tribunal, not the individuals, which also adds a layer of costs for the leaseholders. But it does allow people to hopefully be able to move on and sell their properties if you can get a manager appointed, and also a manager willing to take on that appointment.
Karen, are you able to just explain a little bit about what you can do if there's a clause in the lease which no longer applies?
So with some of the properties in the big cities, we find that they have historically had a communal heating system where the landlord is required to provide either hot water or heating to the entire building. And often in the lease terms, it says that heating will be provided between, say, April and October. What happens is when that equipment is at the end of life, the freeholder, managing agent, needs to replace it. And with improvements in technology, it's now no longer cost effective to replace a communal heating system. But that causes problems for the landlord because they've got these obligations in the lease to provide it and to charge through the service charge the costs of it. The leaseholders often say, well, we're not going to pay for that, it's too expensive. We would prefer to have control of our own heating system. The only way to deal with that is to try and get agreement of the leaseholders, but then you have to make an application to the tribunal to vary the terms of all the leases. You can't just vary one or two. All of them have to be varied at the same time, which is why you have to make the application to the tribunal. The landlord doesn't want to find itself in a position where it's obliged to provide the heating system to all of the property, and yet 98% of them have got their own system.
Yeah.
And it's only providing it for 2%.
Karen, are you able to explain a little bit about what happens when a leaseholder doesn't actually pay their service charges?
So the landlord has a number of remedies open to it. The simple one would be to sue in the county court for the money value of the service charges. Landlords need to make sure that they've complied with the terms of the lease, that the demands comply with the legislation, and then before issuing proceedings, there's a pre-action protocol to go through. So they would probably instruct solicitors to then serve a letter in compliance with that. And still, if there's no payment made, the next step would be county court proceedings. Under the terms of the lease, there may be a contractual provision in it for the landlord to recover their legal costs where a leaseholder is in default, such as not paying service charges. As a landlord, it's always important, if you're going to embark on litigation, that you can recover your costs either from the defaulting lessee or generally through the service charges.
Are you able to explain a little bit about the role of a first-tier tribunal when it comes to recovering service charges?
Yes, so with the first-tier tribunal, they determine reasonableness of service charges. So if a leaseholder challenges the reasonableness of the service charges, then the application will be issued in the tribunal, and the tribunal will then give directions and will look at the evidence before it and hear why the leaseholders challenge it. Is it not permitted under terms of the lease? Were the works carried out not to a reasonable standard? Were the value of the work per flat more than £250, in which case it brings it into a long-term consultation, statutory consultation period. If it's over £250 for the works, it's required to consult all the leaseholders as part of the statutory consultation process. If it doesn't do that, then it's limited to recovering £250 per flat. What the tribunal will do at the end is it will make a determination as to how much is owed by the leaseholders, and then that sum will need to be paid by the leaseholders.
I wanted to just touch upon property fraud. There's been a case recently in the news where somebody returned to their property and found that they no longer own that property. Do you have any sort of insights into property fraud, and as a litigator, what you look out for?
One of the first things that we look at when a client comes to us with a property problem is the up-to-date legal register to check that it shows what it should, that the client is the registered owner, whether there's any adverse charges on the property that they weren't expecting. And secondly, we check the address on the land registry to make sure that it is the client's current address and that there is more than just the property address listed. The reason why that's so important is that if the land registry or the local authority are writing to the owner of that property, that they have addresses they can write to other than the property. There's a case recently where a property was fraudulently taken and the only address there at the land registry was the property address. And it's a high risk where there's no mortgage, and particularly where it's rented out to tenants. So it's really important for people to make sure they keep their addresses at the land registry up to date on property. And you can also include email addresses now. And there is a notification service with the land registry, which you can sign up to, and they will notify you of any changes or any applications to change the title at the land registry.
I think that's a really important service that all property owners should sign up to, and it is something that we advise all of our clients to do.
And it's free as well.
It's free.
Yeah. Farzana, do you find that clients come to you selling properties where they have tenants in occupation?
It really depends on what the buyer requires. Most buyers, I would say, would require the property to be vacant. Some buyers may want to buy the property with the current tenant in situ, which is fine. But usually what we deal with is when there is a tenant at the property, when the client is selling the property, they would provide the tenant with the relevant notice. We always advise our clients not to exchange until the property is vacant. It could lead to potential problems where they've exchanged, then the tenant doesn't vacate, and it's essentially a breach of contract, which you probably may have dealt with in your line of work.
I know we're finding it difficult at the minute to try and get vacant possession for people, particularly when they're selling, because there's a huge backlog in the courts. Central London are taking 2 to 3 months to even issue a claim for possession.
Karen, what advice would you give to someone who's looking to buy a leasehold property?
It's very important to make sure that you have a good solicitor working for you on the acquisition, to make sure that you get all your questions answered and that you fully understand what you're buying, the length of the lease, any current issues with the property, and your exposure to service charges, because they can go up, particularly if energy prices go up, then your service charge will go up. It's also important as well to consider with the issues that have arisen from Grenfell, whether any cladding issues, whether you've got the certificate that you need or that the freeholder needs on that to show that it is a safe property and can be transferred. It's really important to make sure that you've got all those questions answered, and also to check what your neighbours are like. Whilst we talk about leasehold and the contractual position, you don't want to be living next door to a neighbour that has caused nuisance with, say, noise for the last 10 years. And that's the real reason perhaps why the property is being sold. So get as much information as you can before you make that decision to exchange contracts.
I think some of our clients, especially when they're buying a leasehold property for the first time, and we point out various covenants and obligations to them, they find it a bit odd. There are obligations where they they can't keep pets, or they have to ask for consent if they want to have a pet in the property. There's another quite common one, which is about carpeting, especially for properties which might be, above ground floor. Usually in the lease, with some properties, not all, is a covenant which says all flooring should be carpeted, or sound deadening material used, apart from the kitchen and bathroom usually. When we point these out to the clients, especially clients who want, sort of modern property with hardwood flooring, it could be a point which actually deters them from buying the property. We find that just clients find it a little bit odd that there's so many restrictions when you're buying a leasehold property sometimes.
That's why it's really important to understand what's in the terms of the lease. Just picking up on your point about the animal restrictions, when I have seen an old lease recently which restricted the keeping of reptiles in the property. Your mind boggles at what they were considering they might be owning. There is a lot of publicity as well now around keeping pets, and I think the tide is turning. I do wonder how long landlords will be able to impose that ban unless there's a real reason for it, such as perhaps there's no easy access to outside space. Is it appropriate for a dog to be kept somewhere where there's no outside space? So I wonder whether that is going to change, particularly with pressure on that. With the wooden flooring and carpet, this is an area of constant disputes. The issue, I think, is noise issue, where you've got people generally just going about day-to-day life with or without shoes, and it's the impact on the floor. And if you're in a flat below, you can really hear that sound. And it's important that if you want to carry out alterations when you have acquired the property, that you check what the carpeting or flooring cover requirements are. And if it is a carpeting covenant, whether the landlord will allow you to install a wooden floor. And if so, are they going to require you to replace it or cover it with carpets if there are complaints? Because the last thing you want to do is spend tens of thousands of pounds putting in a wooden floor and then be told the neighbour downstairs has complained about the noise and you've now got to cover it.
So usually with the flat, you will own the flat itself. There are common areas such as staircases. There could be potentially a flat that just has access to a staircase. Nobody else really uses that. Can that flat owner just stick a door at the end of that staircase and claim that as their own?
So no, they can't. Unless it's in their demise, they don't have the right to what's called exclusive possession, which is the right to use it and nobody else has that right. To do so is probably likely to result in the landlord suing them for trespass because they're not allowed to take parts of the common part and put it into their flat. If somebody was wanting to do that, what I would advise them to do is to approach the landlord and ask for permission to acquire that area, and then you'd either have a deed of variation, varying your lease, or a new lease just for that area. If the landlord was willing to do so, it's likely to be the payment of a premium to the landlord for doing so. And the landlord would also have to consider whether there are any obligations to the other leaseholders to serve notice that he or she is disposing of part of the common parts. Thank you for listening to our podcast today on leasehold issues. We hope that it's been helpful. And at Bishop & Sewell, we are very willing to help you should you have any need to contact us about any of these issues, or indeed any other issues which may arise with your property purchase or once you've purchased it. Thank you very much.
Thank you.
That's all for today's episode of Listen Without Prejudice. Whether you're navigating a property transaction, a corporate, commercial, or family matter, we're here to guide you every step of the way. If you enjoyed the episode, don't forget to subscribe to stay up to date on future episodes, where we'll continue to explore the latest trends and challenges across our core practice areas. Do you have a question or topics you'd like us to cover? Or do you want to reach one of our experts? Feel free to get in touch via LinkedIn or through our website, bishopandsewell.co.uk. Thanks again for tuning in. Be sure to join us in our next episode, where the conversation continues. Until then, take care.